Hello, my name is Mike Hestron. I'm the Riverside County District Attorney. I want to alert you today to a crisis that is unfolding in our courts. Mass criminal court dismissals are occurring in Riverside County due to COVID-19. Last week, more than 200 felony and misdemeanor cases were dismissed throughout the county. These dismissals included serious and violent felonies. The vast majority of these dismissals have been domestic violence cases, both felony and misdemeanor. When a judge dismisses a domestic violence case, they also terminate the victim's criminal protective order. This is nothing less than an injustice and a disservice to the victims and to public safety. Riverside County is the fastest growing county in California, but we have consistently received far fewer resources, including judicial seats, than we need based on population. This has been the case since as far back as anyone can remember. But before the pandemic, we had not had a criminal case dismissed for lack of a courtroom in over a decade. After the COVID-19 forced lockdowns, we currently have a backlog of almost 2,800 criminal cases. Last week, Riverside County judges chose to dismiss more than 200 criminal matters for lack of an available courtroom to try the case. This situation is unsustainable and constitutes a danger to the public. On average, the Riverside County DA's office handles between 50 and 60,000 criminal matters every year. We resolve the vast majority of our criminal cases before trial. But without the assurance that a trial court is available, there's simply no incentive for any defendant in a criminal case to resolve any matter before trial. Unless our courts stop the mass dismissals, our backlog of criminal cases will continue to grow and our justice system will be in danger of collapse. Our courts seem intent on using this crisis to get the attention of decision makers in Sacramento about the unfair allocation of judicial resources across our state. While we agree that the county needs more judicial resources, this is no time to be focusing on anything other than the crisis at hand. Our courts are required to use all available resources to ensure that all cases and disputes can be tried in a court of law and in a timely manner. To be clear, we are not demanding a specific outcome or decision on cases. Instead, we are asking the judges to engage with the facts of the cases and the backlog, both pre- and post-pandemic. We are preparing to appeal these decisions to our appellate courts and to the California Supreme Court if necessary. We're also asking the courts to do everything possible to use the judicial resources we currently have to meet the crisis. For example, during the first week of these mass dismissals, the courts dismissed over 500 jurors without having them try a case due to what seems like mismanagement of resources. This is simply unacceptable. If we have an emergency in our courts that justifies the dismissal of felony cases, then it should be an emergency in every courtroom across Riverside County and should also justify an all-hands-on-deck approach to trying cases. My prosecutors stand ready to try cases at any time. Perhaps the courts should be open to longer hours, hold night court, or perhaps open on weekends until the crisis passes. While these are extraordinary measures, they should be required to meet the crisis and still protect our public. The District Attorney's Office will begin to alert the public about each dismissal and each court action that may affect public safety. We plan to send out alerts on what is occurring in our courtrooms on a weekly basis or as often as is necessary to make sure the public understands what is at stake in their particular community. The courts do not belong to anyone but the people of the state of California, and the people are watching closely what is happening in our courts. Thank you.